Well, second podcast in a week of recording. They won't go out together, of course, but it's good to see you again.
It's great. Second podcast in 24 hours, I think.
Yeah, I know. Yeah. So I can give you an update on Albert if you want, because...
Yeah, we kind of began yesterday or last week in podcast land, and it was exciting stuff. He got woken up by a massive car crash outside your house.
He did.
Tortoise ran out trying to apprehend. Am I confusing two stories here?
You are eliding two stories, I think.
Damn it.
If a tortoise can elide, I suppose they can, can't they?
If anything can elide, it's a tortoise. I've always said
it's a tortoise, yeah. Usually with a croc, as we've talked about previously.
I forgot that. That was horrible.
Not a crocodile, but a croc shoe.
I know what you mean.
Yeah. No, and he was straight into eating. He was out the garden. He's had his lettuce. He's had his cucumber. He's had his vitamins. So all good. Me dropping him immediately before I put him into hibernation didn't do any permanent damage, it seems.
Well, to him, how's your foot?
My foot's never recovered. My broken toe is fixed in an odd position.
How old is Albert now?
He is just coming up for 15.
Okay, so he's got another, 85 years to go or something?
95, yeah, something like that, years to go, yeah. Yeah.
So he'll be going long enough. Podcast is a distant memory.
Yeah, we're going to have to leave him to one of the kids in the will, obviously, so we don't want them fighting over him.
No, true. Can you get the podcast logo on him and use him for very slow kind of publicity?
Take you for a little walk on a lead or something around past land.
Lee Davis and Gwilym Roberts are the two IPs in a pod, and you are listening to a podcast on intellectual property, brought to you by the Chartered Institute of Patent Attorneys.
Anyway, haven't we got a cracking session set up for today? Haven't we?
It's as topical as it gets.
It is as topical as it gets, yeah. So we're talking about Unitary Patent and Unified Patent Court, which I think I've been saying this for about as long as I've been at CIPA now, is imminent. But we've got a couple of experts on with us to help us understand how we've got to where we are and where we're going. Welcome to Caelia, Bryn-Jacobsen and Leythem Wall. Hello, both.
Hey,
Hey, guys.
Who wants to go first, introduce themselves? Celia, you should go first, shouldn't you, really?
Okay, this is my second time on the pod, actually.
I know.
Exciting. Yeah. If I appear 3 times, do I get my own Zoom breakout room or something really exciting?
We could send you a mug or a T-shirt or something.
I think that's in order. Excellent. Yep. So me, I'm a patent attorney, about 25 years now at Caelia and Strode. I know. I have juggled career.
Endorsement there.
Yeah, definitely. I've juggled career and family for a long time. It's been fun. I'm involved in other things, as you know, a friend of CIPA, so I'm on council. And I also chair the committee which organises the events. Lots going on with this topic, the UPC. And I'm also involved in IP ability and also in the new board that's been set up for IP Inclusive. So that's me. Looking forward to talking about this today.
How would you get the time to do all of that?
Plenty of time. I've got a little vineyard as well. I think that's what keeps me going, to be honest.
Leythem, who are you, sir?
So I'm a bit stumped by the vineyard. That sounds great.
Come and help out, do.
Yeah, have a glass. Hi, folks. Yeah, I'm Leythem Wall. I'm a UK and European patent attorney. I'm actually based out in the Netherlands, and I run my own firm, Oxon IP. I've been around the block, so to speak, in that I've been an attorney working in-house in private practice as well. I've also worked for a US law firm. So I've had a really good sort of overview of different perspectives, different experiences and different legal environments as well as laws. And in terms of the extracurriculars, so to speak, I'm part of the CIPA Litigation Committee and International Liaison Committee. I also am on the EQE Committee for the opposition paper, so qualifying European patent attorneys. And also sticking to the European theme, so to speak, I'm part of an organisation on the board of the European Patent Litigators Association, EPLIT, which was set up shortly after this mystical and mythical Unified Patent Court was signed in terms of an agreement, the UPC agreement, by a number of different firms across Europe to sort of come together and promote European patent attorneys as representatives before the UPC. So that's all the stuff that I do, but no vineyard.
No vineyard, just as busy though, if not more so. It's amazing. So we need to talk about UPC, but before we do that, it would be remiss of me having Caelia on the podcast to not ask the question, what's it like working with Gwilym?
I'm still surviving, hence the vineyard, though.
Yeah.
Necessary.
Yeah. So it doesn't just drive you to drink, it drives you to create drink.
Indeed, in large quantities. No, he's great.
So let's talk a little bit about unitary patents and unified patents court. I think we need to talk about the two together probably at the start. There will be people listening to this for whom it's still a mystery. And there will be some for whom they've been waiting for this for a long time and they know the ins and outs of it. So let's be fair to those who might be sort of new to what we're talking about. Can either of you give us an overview of what this is all about?
I can kick off on that. Well, the headline is, it's the biggest, most exciting thing that's happened on the IP landscape over here in Europe, I think, for over 40 years. It has been a little bit like Albert Treacle with speed restrictors on, in that we've seen it coming a long way off and thought it would never happen. And in fact, a lot of deja vu going on. Leythem and I have been talking about this for the best part of 10 years. Yeah. And it really is about to happen now. It really is about, like Albert, heading towards your big toe, Lee. It's coming and it's coming quickly. Interesting from lots of perspectives. It is not only a party that people are getting invites to, but some people are going to the party and don't even know about it. So what is it? It's a new right. So at the moment, when European patents grant, they go off into a bundle of national patents. You choose what countries from the EPC states, 38 of them, you want to validate in. And then they exist after that individually in those states. But going forward, you're going to have the choice to choose a unitary patent, which is going to cover at the moment 24 of the EU states that are part of the EP states. And that unitary patent will exist as a single patent with single actions that you can take for and against it. So you have effectively a pan-European right. You can actually get preliminary injunctions, final injunctions, central revocation, all centrally. It also applies to EPs that have already granted, unless we do something. That's the party with people coming who don't know about it. So if you don't want to be part of it, you've actually got to do something. But I'm going to hand to Leythem actually on the UPC itself, the court side, because that's really his area of expertise.
Oh, wow. Thank you. Thanks, Ian.
No problem.
Yeah, so the Unified Patent Court, again, this is something that's long awaited, long dreamt of, and has seen multiple forms and has previous lives that never came to life, so to speak. And it's essentially a centralised forum for enforcement of patents granted by EPO, and also a centralised revocation procedure as well. Now, we already have, for a lot of you on the podcast, will know about the EPO opposition system, where you can challenge patents after grant, but that has a restriction of a 9-month window. This is something where even after the 9 months, a patent granted by the EPO can be revoked or challenged across the majority of the EU states. So yeah, it's 2 parts, so to speak. It's this new right, which will complement existing rights, and it's a court which will cover this new right and existing rights. But there are slight quirks to it in terms of the territories it covers, when those apply, etc. But in theory, this is a new era of patent litigation that we're coming towards, and something that has been in the pipeline for a very long time.
So I'm normally allowed to ask the idiot in the room question, because I'm not an idiot, but I'm not a patent attorney. So let me ask a question on behalf of people listening who might still be a bit confused. The UK's out, aren't they? So if the UK's out, why are we talking about UK patent attorneys? What's the gig there?
The UK is out as such, but the gateway to all of this is the EPO and European patents. We're still central to prosecuting those European patents. And also we have rights to act in front of the UPC. So we will still be helping our clients obtain those UPs and being central to everything that happens afterwards. And you're absolutely right. If it comes to the grant stage and someone wants a UP and they still want the UK will run alongside that. But we're still central to everything that happens. So you're right in one sense in that we're out, as in a UP won't cover the UK. But the UK, all of us here, European patent attorneys, UK patent attorneys, are still going to be really involved.
So business as usual then?
Not quite. I think there's going to be enormous changes. This is so exciting from a global perspective as well. I mean, before, some big companies would just consider the US, say, because a similar system, you get your one right, covers enormous territory, enormous number of people. And suddenly that's going to happen in Europe. We've got a right, a pan-European right that covers the best part of 400 million people that's easy to deal with. So I don't think it's the same as usual. I think it's exciting in terms of protection. And I think it's a whole different picture on the litigation front, as Leythem will
business
talk more
bigger
on.
and better than usual.
It's bigger and better, yes.
It's certainly more business, that's for sure. I mean, it's business as usual that we continue to do what we do today. And when I say we, I'm talking on behalf of European patent attorneys or specifically UK patent attorneys. But it is going to be more activity. This is something that Caelia rightly points out. UK patent attorneys can be involved in, will be involved in, have the rights to be involved in, but it's also UK businesses. They still have interests outside of the UK. They still have patents in force in these other countries. They still have potential infringers, or they have freedom to operate issues. So this is just more avenues for UK businesses, as well as the UK legal services. And actually, that touches upon the, let's say, hot off the press issue of representation, which has just been confirmed by the relevant UPC committee. Certain rights that UK patent attorneys have will qualify them for UPC representatives. So effectively, that's set in stone now, and there's no debate on that. UK patent attorneys, UK European patent attorneys, should I say, will be able to represent parties before the UPC, as well as today getting European patents and in the future Unitary patents.
I think an interesting point that Caelia makes is of the relevance of the UK patent profession to the EPO. I've actually just done some research on that separately. I don't know if anyone else knew this. In 2019, the UK profession filed just under 40,000 patent applications, which is 3.5 times the next biggest country, which is France. And the only country that far more is Germany. So it does seem like this is where Brexit is so deeply depressing. Of course, the UK was such a huge part of setting it all up. But luckily, I think our relevance on the European patent scene doesn't diminish despite Brexit, which is fantastic news. And all this expertise hopefully should get used quite well. So maybe Leythem, I mean, any commentary there? I mean, the UK was really instrumental in getting a lot of this together. Are there any kind of vestiges of our kind of work there, or are we looking at a more kind of European system going forwards?
Well, I think that there are definitely very clear remnants. There are clear signs of the UK influence, particularly with the UPC procedures. I think a lot of the legal aspects, procedural aspects of the Unified Patent Court, things relating to discovery or expert witnesses, these type of things. There's a lot that reflects what we see, for example, in UK litigation. So I think there's a basis there. But of course, what the UK exit from the European Union means for now is that we won't have UK judges adjudicating at the UPC. So while we have this UK flavour, at least in black and white, what we won't know is how that's enacted once the court is up and running. So yes, and we'll see.
There's two interesting points there, isn't there? There's Brexit, which we thought would separate us out, actually means in practice we're going to increase our collaboration, particularly on infringement, with our partners. Who'd have thought? And the other side, of course, is oppositions. Oppositions become this really powerful tool. Leythem referred to them. There's a 9-month window after grant of current European patents where you can take out all the countries. You can't do that afterwards. So now oppositions become, of increased importance. because there is that potential to wipe out essentially after 9 months all of the states. Whereas, of course, for the UPs, it would just cover the states that are party to the UP.
Yeah, absolutely. And I think a fundamental point to note is that oppositions will be there for unitary patents as well as patents granted in the current form as sort of the bundle. And also the UPC agreement is explicit in that the law that will be applied in assessing validity will be European Patent Convention law. And it even cites the actual articles of the UPC. So there really is, a lot of overlap there. And as Caelia says, oppositions will be important to get that wider jurisdiction for freedom to operate. But equally, the UPC revocation procedure will be there for the entire lifetime. So definite interaction, and the rules of procedure also refer to oppositions about accelerating oppositions or staying UPC actions pending the outcome of opposition. So it's been taken into account by the authors of this new forum.
So you've got 400 million people, a pan-European injunction, pan-European or preliminary injunction, pan-European damages. Sounds like an absolute no-brainer, but there's this opt-out opportunity. Why would anyone want to opt out of this?
Why would we want to opt out? So there's also the problem of pan-European revocation. So if that's something you were worried about, if I was someone with an existing EP right at the moment, I would seriously consider opting out to avoid that if it was one of my real central patents that I was worried about losing, centrally in all those different places. And then there is the option to opt back in if you needed to use some sort of central infringement procedure. The only caveat with that, as I'm sure Leythem will pick up on, is if something kicks off in one of the forums in the meantime, you get pinned to that particular forum. So the opting in, opting out, which can only be done once, still carries risks. Yeah, but the major risk at the moment is that central revocation for someone who has something that's so important in their portfolio, I'd say.
And are there any sectors of businesses that's particularly worrying, do you think?
I think the standout would be, pharmaceuticals and the crown jewels, so to speak. And I think the general, theme we're getting is that the important patents would be opted out, and the ones that aren't so important might be kept in to test the system, let's say. But this is talking from the perspective of the big gun and the larger entity. But for smaller entities, this is something where it does provide an opportunity for centralized enforcement, which financially probably might have not been a possibility at all. It's not as simple as that, but I think that's probably the general theme that we seem to hear and come across.
And definitely costs as well. I mean, in terms just of renewal fees, what you can do with a UP is incredible compared to now. I mean, if you were going for more than 5 states, suddenly you're opening up to 24 states, single renewal fee, very easy, dealing with all your kind of post-grant procedures. It's very, very attractive on lots of levels.
So you touched on the other, so there's UP and there's UPC. And I mean, obviously I'm talking about this to lots of people as well. So I'm kind of, I know too much in the sense, but definitely one of the questions that I keep getting, and I have to kind of clarify really carefully to people who are a bit confused, is the relationship between the EPO, the UP, and the UPC, because I think there's still great confusion about the idea that you can get a UP, but if you don't get a UP, it can still be subject to jurisdiction under the UPC if you don't opt out and everything. Does anyone want to try and get to the bottom of how you unravel all of that? What's the best explanation you've got for how it all fits together?
It's definitely with you, Leythem.
Yeah, good stuff. So yeah, I mean, I think I'm not sure I got the question fully.
I think again, actually, because it was a really, really simple. Somebody from the States who, so I've read about this a lot, and I don't understand what's the difference between an EP and a UP, and why. Yeah. Why does some opt in and some opt out? And they just got really confused. So no, it's a fair question because we take it all for granted.
Yeah, I mean, I think the why I can't necessarily answer or give you a bit more of a detailed explanation. But I think the what is that you have a unitary patent and you can't opt that out. So that is that cannot be changed. If you choose a unitary patent, once your EPO application is granted, then it's stuck in the UPC. So I guess the equation is unitary patent equals UPC. But if you go the route we have now, which is the bundle of national patents, then it will be UPC unless you opt it out. But this opt-out gets more complex because it's only going to be available for a transitional period of 7 years, which could be extended by another 7 years. Okay.
This is coming, though. The point is, as Leythem said, it's coming. So at some point in the future, 14 years, all the EP patents that are granted by the EPO for the UP states will be governed by the UPC. So, we need to be in there from the start.
Yeah, and it also raises a question of, we can crystal ball this as, in so many different ways, but, will one day people stop filing or be filing less at the EPO to avoid this system? We don't know what it's going to be like. I hate using this expression, patent friendly it might be, but it might be something that people want to avoid at all costs. And we could see a return to the pre-EPO days, where it was national filings or in that direction.
One thing that's interesting me about the whole discussion about UP and UPC is how so much of it's focused on the litigation opportunities, which are absolutely clear and very powerful. But of course, I don't know about anyone else's practice, but I don't get many patents litigated. And I think if you were to do the maths, I can't believe that more than a very small percentage of patents that are granted by the EPO, which must be over 100 a year, very small percentage of those are actually litigated, taken all the way through, or even probably kicked off to a certain extent. They're there for other reasons, for licensing, for negotiation, or for standards, wherever it might be. What's the message to people who maybe a little bit less concerned about litigation? They'll cross that bridge when they find it. I'm really, really concerned about the budget of getting a portfolio granted. What do we do for them?
I think it's a really positive one. As I said, not only do they get massively broader coverage, but if they did want to consider litigation, then it was there. You say not many people do it now, but maybe that's because it is so incredibly complex and has to be done at so many different national offices. So I think this is going to be quite a spur to that kind of thing. So yeah, overall, I still see it as a very positive thing.
I mean, I look at it, or I look at another set of statistics when I think of this question, or in addressing this question. In the EPO statistics of oppositions, and how many patents are challenged at the EPO, and it's around 3 to 5%, but it's thousands of patents are challenged each year. And the UPC revocation action is not limited by this 9-month time window, and it is another tool for freedom to operate. And actually, what I think back to, and I mentioned at the start, for a time I was a partner in a US law firm based in London, and that was just I joined just after the American Invents Act came into place. And the highlight or the headline of the American Invents Act was we're moving from first to invent to first to file. But the tag on to that was a post-grant opposition system that came into play, this inter partes review and post-grant review and covered business methods. And, no one could have predicted how much that would have taken off in two ways. Firstly, in its use. Secondly, in its success, so to speak, for the challenges, though I think it's calmed down from its early days. But seeing that and living through that and firsthand as well with a lot of US colleagues, I think that business do need to think about, if I'm going to be in this system, this is a threat, particularly for the unitary patents. So, we're saying the same thing again. It's, you've got the good coverage, but you've got that risk as well.
But the business side is really interesting, actually. I mean, I, like Gwilym and yourself, Leythem, joined the profession quite a while ago, and I've seen this gradual move to being involved in business decisions and advising businesses, on strategy and what to do, kind of increase. And now, all these different considerations, it's definitely time where we need to kind of talk to our clients and talk to the businesses and work out what's best to do on strategy. And that really feeds into who comes into the profession as well, and how we recruit, and that kind of skill set that you're going to need to be able to handle this and consider all the options. And that's quite exciting, actually.
Yeah, well, I think it's as you say, it's changing the story a little bit, isn't it? And I mean, Leythem, your comment about the impact of the kind of the post-grant attack options now in the US. Certainly American attorneys I've spoken to kind of hate it and they view it as a kind of almost an anti-patent growth in the US system. I think I'd argue we're going the other way in the UK, in Europe, with this, because suddenly we've got this massive injunction, this incredibly powerful tool for patent holders. If you're mostly an asserter of patents, e.g., an entity that asserts patents, if you will, this looks really, really attractive. I absolutely get that. Is it possible that it's going to shift the balance a bit too far towards people who kind of mostly wield their patent portfolios rather than kind of making stuff, to simplify the debate?
I think that there is that risk. I think the counter to that, and this is part of the UK flavour we were discussing before, is perhaps costs. The loser pays so-called system, recoverable costs. That might be something that would put off these entities from asserting weak patents when they're unlikely to win. But this does open a door to pan-European litigation at a lower price and hence more value. Where there's money to be made, people will try.
Yeah, there's some interesting nuances actually in possibilities for forum shopping and really looking into where you want to bring actions and how you do it that we haven't really got underneath properly yet, but it's going to be a massive area and really interesting to see what happens.
Definitely. I think we worked out there's a scenario where you can have a national patent, a utility model in certain countries, European parent that's opted in or gone UP, and the European divisional, for example, that's gone classic route and opted out in one country. It could get really quite interesting and confusing for pretty much the same invention 4 times, and then get a couple of designs in as well. So I can see that. But I think usually I think it's fair to say that when you see these corporations do multiple countries in these areas, they've worked pretty well so far. So fingers crossed it'll find its own way. I guess one of the questions there is going to be what the court's like. And again, Leythem, you were mentioning that the UK put some work into it, not going to have UK judges. Are people bullish about how competent the court's going to be from day one? How's it going to go?
I guess it depends on who you're speaking to. If you're speaking
I'm speaking to you, Leythem. This is a podcast.
Yeah. Speaking to me, I mean, who knows? I think the way I'd look at this, instead of predicting how well it's going to be received or how happy people are going to be, my basic prediction would be that once it starts, people aren't going to look back, and that this is going to be a part of the European patent system, like it or lump it. You were saying, Gwilym, that a lot of US attorneys don't like the post-grant system, but hey, there it is. There will be this period to avoid it, and it is possible to avoid it entirely if you decide to go national route or opt out, etc. So we shall see. I think from the UPC side, and this is sort of my informal conversations, let's say, with the folks behind the UPC preparatory committee and such folk, that there is a lot of confidence in this. It's been a long time in the making. A lot of people have put in a lot of work, and a lot of people are interested in seeing it succeed. The political will is clearly there. We've got this far, despite, I think we should not lean towards the UK as the centre of the world. But Brexit that was a decent-sized stumbling block to address, and the German constitutional complaints, etc. But it's got through this. So I think in terms of it getting up and running, yes. In terms of how well will it run, we'll see. But I think it's here to stay, I guess. That's my prediction.
Yeah, I think you're right. And I also see general enthusiasm, actually, for being involved to shape what happens, because it is a blank slate at the moment. And I hear clients wanting to be involved, to start building that case law, seeing what happens so they know what to do. And also massive enthusiasm from the profession. You have to hand it to UK patent attorneys. I mean, as you know, we run these series of educational webinars. And the first one we did a little while back, I think we had a third of members listening in. It's incredible. You think this is a kind of static profession, but no, then this comes along and everyone wants to know what's going on. Everyone wants to find out and be involved. I've been really impressed. So exciting times, I'd say.
Yeah, absolutely.
Lee, I'm having to carry on and keep going.
I'm in learning mode,
Okay,
so you carry on.
Excellent. So nothing's actually happening now. We all know that. Any guesses? Celia, when do you think it's going to actually kick off? Give us a date.
Oh, wow. So as you know, it essentially kicks off not quite when Germany deposits its papers, which will set a 3-month time period that we're calling the sunrise period, where you can start your opt-outs or asking for early unitary effect. People think that maybe July, September, end of this year, early next year would be my best guess from what I hear. What do you think, Leythem?
Well, I'm going to go on what I've seen other people say. I'm ducking out of this one. No, but I think
Oh, you lawyer.
No, but the man himself, so the chair of the preparatory committee, Alexander Ramsey, what he stated at least at the beginning of the year, so just a few months ago, was that this provisional application phase, which is said to last at least 8 months, his view is it will last 8 months, and that within that period, Germany will deposit its instrument of ratification, but that will occur in this 8-month period, and so essentially come the culmination of the 8 months we're there. So the date that I've seen proposed is 1 October 2022, with 1 July 2022 being the sunrise period start. What do I really think? I think we've seen so many, potential roadblocks here that there may be something. But I would lean towards saying that it's going to be at the very end of the year or the beginning of the new year. Brand new start, COVID-free, touch wood, start to 2023.
Do you get that if you elect for a UP? You get COVID-free as well? That'd be great.
I think so. I think
Brilliant.
I saw that little asterisk at the bottom. Yeah.
So people got a bit of time to think. Some people that I'm picking up on, a lot of people are worried about. It's very nitty-gritty, this, but let's mention it because I think practitioners are worried about it. Is the realities of the opting out process. I mean, genuinely, at the form filling level, it's looking a bit catastrophic at the moment, isn't it?
It reminds me of when the EPO set a short deadline for everyone to file their divisionals if they wanted. I think it will be interesting times. In theory, it should be all right. All we can do is get ahead early, start talking to clients early and finding out what people want and trying to do this early on. I believe they won't be examined as such, but then if they're challenge data, they do need to be correct. So there's lots of issues with who has the right to request an opt-out, making sure if you've got jointly owned applications and patents that the right person's asking and has the right to ask. I think it will be difficult with potential problems, but the sooner we start talking to clients about it, the better. They just have to see.
Yeah, definitely to get on that now in terms of looking at the cases, because the opt-out is only effective once it's registered. So the day you opt out isn't necessarily the day it's opted. You submit the opt-out application isn't necessarily the day it's opted out. The other issues, you need the permission, so to speak, of all the owners of the European patent. So if you've got joint owners, or if you've got owners in different countries for the current European patents, all listed need to be approving the opt-outs. So there is a fair bit of work to be done depending on what you do with your patents and who's an owner, etc. So definitely, the general advice is look at this now, whether it's going to be October, whether it's going to be next year. Get on this now.
Yesterday,
So again, for the less versed listeners, if you've got European patents granted that have already been granted, the point being that if you don't do anything, it will be subject to the UPC in the countries in which it's enforced in the UPC, UP countries at the moment. So it's quite important. Lee, I think CIPA can expect to be deluged by angry requests in the next few months saying, how on earth am I supposed to do this? Something that CIPA gets occasionally. It's kind of not really CIPA's fault, but we may be asked to help on this. It is going to be quite interesting. And one follow-on question, actually, I've not thought this one through. If you say to your clients, I'm going to opt out based on the information you give me, whatever, and then just go ahead and do it. And then it is challenged at some point. Presumably that might mean your opt out is invalid and you've not left the jurisdiction of the UPC. despite the fact you wanted to, and e.g. you can be centrally revoked 10 years after grants, that kind of thing. So there is I'm guessing, is that correct? So there's a question badly framed.
No, definitely. I mean, if your opt-out isn't correct, that can be challenged, and that can mean that you've never opted out. And the correction to an opt-out is only effective from the date of it being corrected. So it's not ab initio, so to speak. It's not effective from when you originally tried. It's from the date of correction. So very careful, please be.
Yeah.
Thank you. And there's got a Yoda-like statement there. Very careful, please.
It was, wasn't
it? Yeah, and in terms of, so the other thing I've been hearing about a lot, of course, is the EPO is going to introduce deferral procedures so that you can hold up grant of your patent until the UP is available. Anything that people should be doing right now on that front?
It's worth reviewing cases, and we're doing that actively with clients for the cases that we've had intention to grants on, to delay those ones in case you want to be part of the UP or ask for a UP rather. So yes, definitely have a look at what's going on. There's all sorts of procedures now you can use, rejecting text, don't want to be boring with details, or further processing to kind of delay them, to bring them effectively into the sunrise period. Once we're in that period, there's other mechanisms for delaying, but to bring them to that sunrise period, any that are near grant now, yes, we need to look at what's going on now, definitely. Yet another thing that clients need to be looking at now, or yesterday.
Excellent. I've got two more things. And the second one is designed to make Lee sweat and cry at the same time. So I'm looking forward to the second one. The first one is, I don't think we've mentioned the translation point for UPs, that you have to put a translation in. My understanding is that it's not supposed to be a machine translation. If that's correct, and we do have a lot of deferred cases or a lot of interest early on, are we going to see a massive backlog, just a traffic jam of actually getting translations done? Is that something that needs preparation? What's going to happen? What language are people going to use?
Yes, so for the Unitary patent, what it's going to be is that if the patent is filed in English, then you need a translation into another EU language. Whereas if the patent is filed in French or German, then you need a translation into English. So that's the requirement for the UP. So that's that issue. But I don't know, Gwilym, if you're touching upon when you're validating a European patent, or you're talking about claims translations.
I think validating a UP will require the additional translation. That's right.
Yeah. So that's what they're asking for. And yes, initially it won't be a machine translation, but the idea is that after a transitional period, which I think is up to 12 years, after that they will believe in Google or whichever translating machine that they are producing, good enough translations.
Yeah, it's a short time scale actually for getting the translation, because it's of the whole spec. It's only a month, and we're used to 3 months. But that said, I understand there is an extension available if you don't do it. So it's feasible. We know it's happening.
I really want to lobby on actually that, because I can just see straightforward practical issues with a backlog. So that is the make Lee sweat question. Just quickly, Bryn News, the UK profession, can represent in the courts and everything else as can any other European attorney, given as long as they have the relevant background qualifications, which the majority of the profession automatically has, which is brilliant. But as with all things Brexit, we also have to think quickly about visas. Lee, you love visas. You had a great time last time round, didn't you?
Lee's got a massive smile on his face here. Go on.
That's so terribly unfair, because if I hadn't mentioned it to you before we started the podcast, you wouldn't even know about it, mate.
I had forgotten. It had been raised to you, but I'd forgotten. Somebody did say, what about visas? What about visas, Lee? What are we going to do?
Well, we certainly need to look into it, and we'll do that. We've got a bit of time this time. A little bit different to how the visa thing bounced on us in terms of the trade and cooperation agreement with the EU, when we realised that we would need to do a piece of work there whilst we were still trying to actually do our jobs. This time round, we got a little bit of lead-in. So we'll get cracking on that. There's a conversation that we need to have with our friends and colleagues in government departments such as Department for International Trade, the Foreign Commonwealth and Development Office, who helped us last time when we looked at visas through the lens of needing to access the seats of the EPO. Similar issue here, obviously. We've got the central divisions that we need to think about, and then we're going to need to think about whether that extends to the local divisions. What we learned when we did the piece of work on continuing to be able to access the EPO is that this isn't an EU issue. This is a issue for national immigration authorities, which means rather than having one conversation centrally, we're going to need to have these conversations multiple times with multiple jurisdictions. So I think it's probably a similar piece of work to the piece of work that we did around rights of representation at the EPO. To my mind, the basic argument, the principle is the same. We have a right of representation, a right of audience that's enshrined in a treaty that we are members of, this time by virtue of being European patent attorneys, so similar to the EPC in that sense. And so I think the legal basis is the same, but that doesn't mean that it won't be a bit of a sticky job having all of these conversations across the UPC signatory states. So yeah, it's a bit of work to do, Gwilym. I know I've got to do it, and we'll be on it.
So basically, the whole of the UK profession is relying on you, Lee.
Yeah, no pressure.
It usually does. It usually does.
I'll hand it back to you, Lee. Sorry.
Yeah, no, so I'll just ask my normal question. I mean, Gwilym gave you a fair drilling there. Apologies, I sat on the sidelines. I was just in learning mode, and I learned a huge amount. Is there anything, are you sat there thinking, phew, they didn't ask us that difficult question. What have we let you get away with?
Oh my God, there are so many known unknowns and unknown unknowns in this. You know, Donald Ransford would have an absolute field day here. I can't even begin to go there. There's so much up in the air.
No, you can't leave it like that. I've asked you the question. You know,
I really can. You see, I've done that bit now. I hand over to Leythem and he'll fill in all the complicated bits.
Oh, will Germany leave the EU?
Is that a rumour? Can we start that now?
No. I'm going to get a lot of trouble for that.
Finally, the podcast goes viral.
I think the point on the litigation on bifurcation and forum shopping, there's lots of unknowns there. I'm not quite sure how that's going to work out. That's the biggest unknown area for me. But, you know, the major principles are there. We know what's happening. Yeah, bring it on.
So, I think I've heard at least 2 calls to action. The first was to rights holders and potential future rights holders. You got to do stuff now and do stuff early and get in and get it sorted. Yeah. So to do that, you need to speak to a patent attorney, UK patent attorney. And if you're a UK patent attorney, you need to be inside this right from the start.
Definitely.
And to do that, you need to access your CIPA CPD. Yeah. You
do. Events 2nd of May. Let me see. 2nd of May and 10th of May, I think, coming up. Have a look on the CIPA website. I'm plugging events now, but yeah, definitely be involved.
Gwilym, anything more from you?
No, that was really, really good. I think
it's a great one, wasn't it?
Really helpful. It's quite nice to add to our resource, actually, things to learn about the UP and UPC from, because that chat is quite useful. There's the amount of information we've got through, and forgive me for asking a couple of slightly oblique questions, but I keep getting asked them myself, and I thought I just bounce, and I've got the answers now, so thank you. That's really helpful. No, it's a huge opportunity. I personally think it is exciting, particularly for, should we say, patent asserters. I think the implementers have got a bit more thinking to do. My personal view, by the way, following off kind of some of your comments, Caelia, that I think we might see a bit of a resurgence of the European Patent Office of getting patents out, killed early.
Yeah.
So the opposition procedure and the other stuff we know about, third-party observations, we might see that picking up a little bit. It's never been that expensive, and it is, as you say, massively powerful. So that might be something that EPO needs to keep an eye on. And I think we need to get the opting out paperwork sorted, because it genuinely does sound horrid and difficult and disproportionate. And Lee, I think that's something CIPA can do a bit of work on. And maybe, actually, I haven't thought through the translation thing fully. Maybe we can start lobbying that, saying, have you considered the risk that we're going to use up the whole of Albania's translation regime, or whatever country people go for, just getting these things done? That could just be a genuine logjam. So that could be interesting too, from a purely logistical point of view.
So thank you both for coming on. It's been an absolute pleasure having you. It's been a really good one with us. I mean, Gwilym and I have had a great week. We've done 2 podcasts this week, and they've both been absolutely full of energy and enthusiasm. And I can't wait to listen back to them. Thank you both. We'll need to get you on again. I'm sure this will be a recurring theme. So we'll have you back, and then Caelia can bag her hat trick.
Yes, I'm waiting for that. and the mug, please.
Yeah.
Hey, Gwilym, I might let you back on again as well, if that's all right.
Oh, thanks, man. I'm around.
Got a couple of questions for you at the end, though, if that's right.
So
you.
Oh, God, okay.
How is little baby Beth?
Oh, thank you. She is lovely. She is on a nappy rotation regime, which is quite unbelievable.
She must be smiling and gurgling and things now, surely.
Yeah, occasionally. She googles all over the place from all kinds of different places as well. It's just, yeah, I mean that bit, it's all very scatological at home at the moment.
And second question, when are you going to be allowed out to play again?
Oh, Lee, you know how hard I've tried.
About 5 years.
I want to do some more pubcasts. That was one of the
That was what I was thinking. That was what
I
I was
know. Well, I
Absolutely.
keep trying to do it, and then there was someone called really keen to do that, and we should get a live. I want to do a live one, get a live audience in. We could do the Albert Hall, maybe. I think we get that kind of, it's only a matter of time now.
Thanks all. I think we'll call it a wrap.
Thanks, guys.
Thanks so much.
Good to see you all.